CR 2016-13197, State of Idaho versus Jeremy James White. Mr. White is present, along with counsel, Mr. Jordan Crane. State of Idaho is present, represented by Prosecuting Attorney Danny Clark, as well as Ms. North Shaw. We're here today for a scheduled sentencing. Are the parties ready to proceed, Mr. Crane?
We are, Your Honor.
Mr. Clark?
We are.
All right. Mr. White, let me review the history of your case for the record. On February 20th, 2016, you were brought before this court and informed that information had been filed against you by the state of Idaho, charging you with the crime of murder in the second degree. At that time, you were advised of the potential penalties involved, your constitutional rights, your plea options. You pled not guilty on that date. However, on July 13, 2017, after a mediation in this case, you entered a plea of guilty pursuant to a plea agreement, which was a binding plea agreement. You pled as guilty as charged to murder in the second degree. There was a specific sentencing recommendation attached to that. That's binding sentence of 45 years, with 15 years of that being fixed, 30 years indeterminate. There was also an agreement that the no contact order would remain in place during the court's jurisdiction. You also agreed to pay restitution, and as indicated, this was a binding plea agreement. After the court accepted the guilty plea, order the pre-sentence investigation report be prepared. I have received that report and reviewed it. A copy of it has also been provided to your counsel and to the state. Let me ask, Mr. White, have you had a chance to review that pre-sentence investigation report with your attorney?
Yes, I have.
All right. Let me also indicate that is consistent with my practice. The court will not indicate whether I will accept or reject the plea agreement until following the argument of counsel and the presentation of evidence. Mr. Crane, are there any parts of the report that need to be clarified or corrected?
No, Your Honor.
Mr. White, you wish to stand by the plea of guilty you previously entered in this case?
Yes, I do.
Mr. Crane, are there going to be any witnesses for the defendant?
Your Honor, other than the statements that have been attached to the pre-sentence investigation, we don't have any witnesses.
I indicate I've read through all of those. I appreciate that. Are there going to be witnesses for the state?
Not witnesses, victim impact statement, Your Honor.
Mr. Crane, before I impose sentence in this matter, I'll give you the chance to argue on your client's behalf.
Thank you, Your Honor. We're going to ask that the court adopt the parties' joint recommendation of the 45-year sentence in this matter and impose that here today. That sentence appears to be right in line with similar type offenses, and there was a lot of effort and work, consideration put into reaching that recommendation, and we think it's fair considering all the factors that we looked at, that the state looked at, and would ask the court accept our agreement and impose that sentence today. We're here on a very difficult case. I'll keep my statements kind of to a minimum. That's kind of how Mr. White would prefer it. Some of the concerns I noted in the pre-sentence report, perhaps about an attitude or kind of his demeanor during the pre-sentence process. I can tell the court that over the last 9 months that I've come to know Mr. White and represented him and spoken to him about this case. Not once did he try to disparage Christine's memory. Not once did he shirk responsibility. Not once did he try to make himself look like a victim or explain away what had happened or provide with me an excuse. This case probably could have been resolved months and months ago had it not been for the fact that our system's set up to make sure things are done correctly, that I had a job to do, that there were piles and piles of evidence, statements that had to be gone through on my end. Mr. White waived extradition, waived his preliminary hearing. He participated willingly in mediation. I said, I think doesn't want me today to come here and provide an excuse or justifications or anything to make light of the reason that we're here today. It's a tragedy. There's an impact on our community, on families, on his family, on himself, and Mr. White accepts that. And would just like the court to know that we're not here to present any excuses. And would ask the court accept the agreement that we've reached and impose that as the sentence today.
Thank you, Mr. Frank. Mr. Clark.
Thank you, Your Honor. I appreciate Holly and Shaylee's statements. We go around and around in these cases. We've done, this court's had experience with these, I've had experience with these, and there are different cases within the criminal justice system where this court or myself can make a victim whole. There's cases where we can do that, and it feels good to do that. A case like this, we just simply can't. What this court must do is level out mete out a punishment that fits the crime. I'll speak more to that later on, but I don't want to in any way suggest that we can make this right, because we simply can't. It doesn't matter what this court does today, we simply can't make it right. But we're going to try. As the court has mentioned, we went through a mediation on this case. A lot of time and effort, energy that we spent with the victims on the case to discuss the different options, where this case, the strengths and weaknesses from just a purely evidentiary standpoint. We discussed those. We discussed, I think, was a significant desire on their part for the defendant to give a statement. The court, I think, is aware that the defendant gave an allocution, so to speak, after the guilty plea. That was part of the agreement that was important to them. I think it played a significant factor in reaching the agreement we did. What was important from our perspective is this was charged as murder in the second degree. That was done somewhere in the middle of the night as we began this case. What I can tell the court now, many months later, is I've seen no evidence to justify a reduction of the charge. I've also likewise seen no evidence to move the charge to a first degree. I haven't seen any premeditation evidence. One of the reasons it was important in our perspective, to not only have the defendant give a statement, which he's done, but also to use the co-defendant Ms. Aday's statement, is to fill in what occurred during the time frame. We knew what led up to it. The court has reviewed the evidence of what kind of led up to this. The court's reviewed the evidence that occurred after the fact. There wasn't any evidence at all of what actually occurred. The autopsy was somewhat inconclusive as to the cause of death was strangulation, but it also didn't say why or how or with what mechanism. And those were things that were important to get an answer to those questions by the defendant. That's part of the reason we reached the agreement we did as to the 45 years. And also why we wanted the defendant's statement. I want to walk a little bit through the facts of the case. I think the court's familiar with them, generally we're familiar with them, and I want to walk through some of them in order to point out some things later on. November 7th, early morning hours of November 8th, the defendant strangled his wife with his hands, killed her. After that time, he then buried her in the basement. He buried her in clean clothes, pajamas, jewelry, and a makeshift grave. Those were specific things that we knew at the time this occurred, but the public did not. One of the reasons this case turned the way it did was after interviewing Ms. Aday under an immunity agreement. She gave specifics as to what the defendant had told her about what he buried her in. The reason that was important is that wasn't public knowledge. So we knew the statement given to us by Ms. Day was corroborated by the physical evidence, and it was also truthful. The defendant then made plans, even went so far as to act like he was the victim in texting other people and communicating with them, and left town with Ms. Day. They went to Oregon. During that portion, they got rid of their phones, so they couldn't be tracked. They went to Oregon and camped for some time before going to Nevada, where the defendant was going to see his father, from what I understand, one last time before they disappeared. He was caught in Nevada with Ms. Day and extradited back to Idaho. Let me talk about something that's been resonating with me for some time. It's been talked about a lot in this case. I appreciate Ms. Coolidge's statement. It was actually her statement in the PSI that we had thought of this, and that is, this case is about choices. Over and over, I have been asked, and the question has been posed, perhaps rhetorically, is why didn't he just leave? He made a choice. Instead of leaving, he chose to murder her. Again, he recounts what he did next and why, and he chose to bury her in the basement, obviously with an attempt to clean up or otherwise get rid of the crime scene. He made a choice to do that instead of calling the authorities. He cleaned up the bedroom, cleaned up the evidence, removed it from where it was and tried to hide it. All of which was a choice to get away with the horrific crime that he had committed. As I said previously, texted family and friends, saying that he wasn't coming into work, sometimes texting as if he's her, saying he was not feeling well, or that she was not feeling well, was not going to be into work, or didn't see her family. All of those choices to perpetuate or compound the crime that he's committed, rather than coming clean with it. He mentions in the mental health assessment that was one thing that he wrestled with, and yet he chose to continue this farce to the detriment of the victim's family. Fled town, destroyed phones, stayed on the run. It's important to note, Your Honor, he was caught in Nevada. Sometimes this court will deal with defendants who turn themselves in, and that's put in a certain category for the court to consider. This defendant was caught. He was caught with one last visit to family before leaving forever. All of those choices that he continued on with while this case was going on. And this is what I think Hawley points out best. With the choices he made, he also removed choices from the victim and her family. We've got sisters who don't grow old together with Kristen. We have children who grow into maturehood and adulthood without their mother. We have grandchildren who either won't ever know or won't know long enough their grandmother. All of those choices are removed by the victim's family because of those choices the defendant made. Selfish choices. Now, it's appropriate for this court to consider both the mitigating and aggravating facts. Mitigation, there's a couple things I think that are important. First of all, the defendant has admitted guilt. That was important for us. It was very, very important to the victim's family as we went through the mediation. I won't go into any specifics, but as we got towards the end of the mediation, it became very important for them for that chapter to close that day. And ultimately, that's what resulted in doing what we did. It's important for them to do that. I think it's important for the defendant to do that. And so that's certainly a mitigating fact in his favor. He's not contested in any hearings. He gave an explanation as to what happened, why. I don't know that it went into the detail that I would have liked, but frankly, he gave an explanation as to the mechanism and how this played out during this window of time that we just simply had no information of. In this case, as is generally the case for these, the aggravation certainly outweighs the mitigation. First of all, we have the crime itself. As I mentioned when I started my comments, you can't make this right. It doesn't matter what the sentence is, it doesn't matter what this court does or doesn't do, we can't fix this. And that's a difficult burden to deal with. And I think this court has an obligation and can make an effort to try that. One thing that was mentioned to me, as we discussed the appropriate, and I'll speak in a minute to other similar cases, one of the things that was mentioned to me was, well, there wasn't a weapon used. That's a mitigating fact. I disagree. What is more aggravating? Shooting someone from across the room or strangling them from 6 inches away and watching them die in front of you? Which one is worse? And not only that, the person you're doing it to is for all intents and purposes your wife. Which one of those is worse? I would suggest the latter. And I think that aggravates this case. Makes it worse than the others may have been. If you look at the last page on the PSA, it talks about the sentencing database and other similar cases. I realize that the average case for this charge, the average sentence for this charge with this defendant, these priors, things of that nature, is approximately 11 years to 30 years. That's the state average. We felt and continue to feel that this case is more aggravating than what this court would otherwise see for a second-degree murder charge. The aggravating facts that I spoke of here, the personal nature of the murder itself, the lack of any viable explanation. I mean, there really isn't anything that's ever been said to make it understandable, if you understand what I'm saying there. Just simply no justification, no explanation that even makes sense on this case. He simply could have walked away. That is the question that continues to be asked of everyone that I speak with, and yet he chose not to. And he killed someone in a very personal way. And then these choices he continued to make after that, I think, further aggravate both the crime and the deserving sentence. So that's part of the reason we're recommending or asking the court to adopt the sentence that we've agreed on, is because it deserves a more aggravating sentence than an average sentence this court would deal with. You know, for those reasons, I appreciate the court's attention. We're going to ask the court to adopt the sentence that we've agreed upon of 45 years. That is, for all intents and purposes, a life sentence. That was the state's intent. We'll ask that 15 years of that be fixed. We're going to ask for a no contact order to remain in effect until September 20th, 2062. That's 45 years from today's date. For those victims that already have a no contact order, we're going to ask that the no contact order against Kendra Littleford be dismissed. That is the request she's made. I think she'd like to heal in her way and would like some contact in order to facilitate that. We'll leave the civil judgment in the victim's behalf at the court's discretion, as well as any fines or anything else. If there's any questions the court has, I'd be happy to answer them, but that's all I have at this point.
The only question I have is the no contact orders. So currently, there's no contact orders with all of the family, but the only one you want to not have in play, continue in place is Kendra Littleford.
Correct. Holmes. Sorry, Your Honor, Kendra Caldwell. Got my names mixed up, that's the last name of it.
All right, now we're going to, thank you, Mr. Clark. Mr. White, before I impose sentence in this matter, I will give you the chance to address the court. This is known as your right of allocution. This allows you to make a statement on your own behalf or to present information if you choose to. This is for mitigation purposes. You are not required to make any statement, however. You are going to address the court, please.
I don't have a statement this time, Your Honor.
All right. Are you fully satisfied with the representation your attorney has provided you?
Yes, I am.
Mr. Crane, is there any legal reason why I should not sentence the defendant today?
Not that I'm aware of today, Your Honor.
All right. Mr. Jeremy White, based upon your plea of guilty in this case, it is the judgment of this court that you are guilty of the crime of murder in the second degree. Let me indicate that in preparing for this sentence, I have carefully reviewed the pre-sentence investigation report. I have listened closely to the argument of your counsel. I have listened to the argument of the state. I have carefully listened to the victim impact statements and thank them for coming today. It's emotionally difficult to come and to testify or to give testimony about such a loss. And I appreciate the comments that were made, both submitted for in the pre-sentence investigation report as well as the comments that were made today. I have also carefully considered the objectives of criminal sentencing, and I want to address those in light of the nature of the case. These are the objectives adopted by the Idaho Supreme Court in the case of State v. Toohill, and they specifically address what my obligation is today. First and foremost, the court has the obligation of protecting society. This is a heinous crime. Murder is the most serious cases that we deal with in the criminal world. Certainly, society has the right to be protected from crimes such as this. The court has the obligation to deter you and others from committing this type of crime. And the state has argued this was a crime of a personal nature, and the court would agree. And the court has that obligation. The court also has the obligation to consider the possibility of rehabilitation and also punishment or retribution for wrongdoing. I've often considered the objectives of criminal sentencing in light of these types of cases, and the state addressed that. Nowhere in the obligations does the court have the obligation to try and make this right, because I can't. The court cannot do that. There are in a property case, for example, a grand theft case, I handled the sentencing of that nature earlier. I can require money be paid back. I can require that the victim be made whole. But I think, as illustrated by the victim impact statements, that where they describe the loss, and I'm going to call it the loss of opportunity and possibility to be with Kristen. There's nothing that the court can do, and I want to acknowledge that and just indicate that unfortunately there's nothing that society can do, the court can do to change what you did. The court can't undo it. The law can't undo it. Society can't undo it. By your actions, you took away those options. You can't make this right. But I think it's also, the court has to acknowledge the fact that there's nothing I can do to do that. And so I have to consider those objectives of criminal sentencing adopted by the Idaho Supreme Court. But that is also why these cases are the most serious of cases and carry with it the most serious of penalties. As I have listened to the statements and the argument of counsel and considered the pre-sentence investigation report, I ask the same question that's been asked. Why didn't you just leave? The state referred to the victim in this case. Kristen called it was your wife. I think it was a girlfriend. I know you've been living together. You were having an affair with someone else. And as I thought through why you didn't leave and why this crime occurred, I think that you'd gotten used to her taking care of you. And that she was a good person, you liked the situation you were in, and you were hesitant to leave that. However, you also wanted to not have any obligations. As I reviewed the crime, and the state has gone over the details of that, so I'm not going to go through the details here other than to acknowledge what the state has indicated as the facts of the case. Other than to say that the description of the crime and the way that Mr. Clark has described the crime is horrific. To strangle someone who you care about and be within inches as you take the life with your own hands. And then to continue to read what happened afterwards with the bizarre behavior of burying her, but at the same time dressing her up, cleaning her up, putting jewelry in her hand is just bizarre behavior. I recognize that you were in a state of shock, that you weren't thinking clearly within the first few hours after the crime. But then you continue to mislead the family, continue to try and hide the crime. You misled the victim's family in this case. You then fled to Oregon as described by the state, and then ultimately you were arrested. In mitigation and reviewing this, there does show an addiction issues. You've been addicted to opiates for a long period of time. You yourself had abuse issues that you've only begun to deal with. And I recognize those as mitigating circumstances. But even though those are mitigating circumstances, the court finds that there are certainly no excuse, no justification in any way. And once again, I'm left with the same question that has been asked and Mr. Clark and KT's been asked. Is she could have just walked away. There wasn't even a legal commitment to the victim in this case. Kristen Caldwell was 48 years old when you murdered her. She would have lived likely another 30, 40 years, and you took that from her. I've also carefully considered the criteria set forth by the Idaho legislature in Idaho Code 1925-21 relative to the question of whether I should place you on probation or confine you to prison. And I've noted both the mitigating and aggravating factors in this case. Touching briefly on your past criminal record, this is your second felony, but certainly nothing close to this crime. As to why you did what you did, I'm left with the fact that it was a horrific crime and bizarre behavior. But taking into all considerations and considering all the factors that I'm obligated to take into account, let me indicate with an acknowledgement that no matter what the court does, it's not going to change the results for the victim's family. I have decided to accept the plea agreement in this case. So based upon that, it's going to be the judgment of this court that should be sentenced to the custody of the Idaho Department of Corrections as follows. For a total unified sentence of 45 years, with a minimum sentence of that being 15 years, followed by an indeterminate sentence of 30 years. I'll give you credit for the amount of time that you've served. That'll be in the judgment conviction. I'm going to order a fine in this case of $10,000, standard court cost payments into the Victims Relief Fund, a civil penalty of $5,000 is just the maximum the court can order as a compensatory civil penalty for the family of the victims, or the family of the victim in this case. Mr. Clark, was there any restitution at this point?
Not at this point, Your Honor. I'd like to address that separately.
Okay, the court will allow 30 days, and if the state needs more time, then they can file a motion to extend that time, allow 30 days to file a restitution. I am going to reimbursement the county for public defender service amount of $500. I'm going to order the collection of a DNA sample and the right thumbprint consistent with Idaho code. You're advised, Mr. White, you have the right to appeal the Idaho Supreme Court from this judgment conviction. You have a right to be represented by an attorney in that appeal. You cannot afford an attorney. The attorney will be appointed for your public expense. However, you only have 42 days from today's date to file that appeal. You also have the right to seek relief under Idaho Criminal Rule 35. This gives you 120 days to seek a correction or reduction of the sentence if you feel it was illegal or unduly harsh. You also may have the right to seek relief under the Idaho Uniform Post-Conviction Relief Act. However, such an action must be filed within 1 year from the date this right to appeal expires. If you have any questions about any of these rights, please consult with your attorney, Mr. Crane. Do you have any questions, Mr. Wright, about the sentence I've given you in this matter?
No, I do not.
All right. Then I'll remand you to the custody of the Bonneville County Sheriff's Office for execution of this sentence. Be transported to the Idaho Department of Corrections. We'll be in recess on this matter. Thank you.